to order at 7:03. I'm sorry for the delay. If we could please stand for the Pledge of Allegiance. Thank you, board members and participants. Just for the record, we have two board members that are participating remotely this evening, Mr. Fowler and Ms. Mulrenin. You can see them on the screen. Roll call. Ms. Griffin?
Adam DeYoung.
Mr. DeYoung is excused. He had a conflict.
Megan Doyle.
Here.
Andrew Fowler.
Here.
Emily McDonough Souza.
Here.
Holly Mulrenin.
Here.
Una Petrosky.
Here.
Betsy Ratner.
Here.
Cindy Wolf Boynton.
Here.
And Susan Glennon.
Here.
8 members present.
8 members present. Thank you, Ms. Griffin. So this evening's committee of the whole meeting is devoted to some policies for a first reading. I will turn the meeting over to Dr. Fettigan to start.
Thank you, Mrs. Glennon. Good evening, members of the board. The first policy for discussion tonight or review is policy 5145.5, non-discrimination, and you'll see a note on the board agenda that says rescind. You'll notice the first policy in the packet is policy 5145.5, exploitation and sexual harassment, with the X running through. And the policy behind is numbered policy 5145.44, and that is the non-discrimination Title IX policy. And the reason for the recommendation to rescind policy 5145.5, non-discrimination, is largely due to the fact that the new Title IX regulations and resulting final rule that's been approved requires us to have very clear Title IX policy and associated regulation. So because the Title IX policy is represented in 5145.44, it is the more current and relevant policy to replace the one that was previously mentioned. You should please notice that in the policy 5145.44, non-discrimination Title IX, there is the opening statement that the board agrees to comply with Title IX of Education Amendments of 1972 and the regulations as amended in that final rule that I was just mentioning a few moments ago. Title IX does apply to the persons in our district because of our educational programs and activities that do receive federal financial assistance. The policy includes several definitions as outlined on pages 1 and 2 actually, including the definitions of sexual discrimination and sexual harassment. It's important to note that prior to the final rule of the Title IX regulation, federal regulation, sexual harassment was not listed previously. But as a result of the final rule, sexual harassment was more squarely defined. This policy is also very important in our school system and others because it talks about the notifications that are required of our school system with regard to Title IX legislation. It also outlines reporting procedures and how our stakeholders would issue a formal complaint. In addition, the policy outlines the district and schools' mandatory response obligations, and something I would draw your attention to is toward the middle of page 3, the piece around supportive measures. That's called out several times within the policy and actually in the final rule, and speaks to the really important interventions that should be considered in our school system to support students and staff with regard to Title IX complaints. You'll also notice that there is specific language about notice of allegation to the parties and specific language around the grievance process. And a new change in the final rule is there's very clear language that there should be a presumption that the respondent is not responsible for the alleged conduct, and that should be maintained, that position, until a determination is made regarding the responsibility, which would happen at the conclusion of a grievance process. Page 5 really talks about the timeline for the grievance process and the number of days. There's very clear outline about the number of days that as a school district we have to notify someone who is making a Title IX allegation and the respondent and their parents and guardians. There is a note in the middle of page 5 that talks about Title IX regulations that need to specify that the decision maker cannot be the same person as the Title IX coordinator. You should know that as a school system, we've had very extensive training that will happen annually with regard to what the responsibility of the Title IX coordinator is in our school system, as well as all of the other roles and responsibilities that are outlined in this policy. Page 6 talks about the standard of evidence and written documentation, and something that I would want to draw the board's attention to in this section is the language around clear and convincing evidence standard versus the preponderance of evidence standard. And our legal counsel and administrative recommendation to the board is to keep the language that says the board has chosen to use the district standard of evidence as the preponderance of evidence standard. That is the more typical approach for school systems. Also in this section, the decision maker, which again cannot be the Title IX coordinator. In our school district, our Title IX coordinator is our Director of Human Resources. That decision maker has to issue a written determination regarding responsibility with the findings of fact, conclusions, and rationale for the result for the allegations, as well as any disciplinary sanctions imposed on the respondent, and whether remedies will be provided. And again, that summary statement would also include very specific information about supportive measures. There is an appeals procedure that's outlined in this policy, and also an informal resolution process, and then some very clear language about record keeping. And so our school system is obligated by law to keep and maintain records related to Title IX for 7 years. And really inclusive of all of the pieces of an investigation and findings, including the supportive measures offered to victims and respondents. There's important information in the policy that, of course, will make known to stakeholders, students, staff, families, and guardians about retaliation. Complaints alleging retaliation may be filed according to the grievance procedures pertaining to sex discrimination. So we want to make sure that in our school district we recognize that the following does not constitute retaliation, and that is talking about rights protected under the First Amendment and charging individuals with code of conduct violations, so making false statements. This is a really important section on page 8 at the bottom, the training piece. As I mentioned before, we do have annual training. We have training that is specific to Title IX coordinator, specific to the other roles and responsibilities, and we also ensure that our safe school climate specialists that are in each of our schools have training in Title IX, because they're the primary investigators. Typically, when a staff member or student has an issue or a Title IX complaint, they would most typically go most directly to the safe school climate specialist, which is typically at our elementary schools, the teacher leaders, and at the middle schools, assistant principals, high school assistant principals, and deans of students. And there's, of course, the non-discrimination notice at the end of the policy, and there are legal references included that are important to crosswalk against the policy. I'm happy to take any questions.
Thank you, Dr. Fettigan.
You're welcome.
So, board members, just to be clear, the first reading on our agenda is for the rescission of 5145.5. We're not considering 5145.44 for revision. It was just included for information purposes.
Correct.
It seems to me that 5145.44 is certainly the more comprehensive policy of the two. And am I correct that it incorporates information that was in that is in the policy that we're
It does.
rescinding? Okay.
Absolutely, and especially because the Title IX policy does squarely define sexual harassment. 5145.5 is no longer relevant, and it's not as specific as you indicated.
So board members, do we have questions for Dr. Fedigan? Ms. Doyle?
Hi, thank you. You mentioned it before, on, page 8. I'm unclear on the district recognizes the following does not constitute retaliation. The exercise of rights protected in the First Amendment of the Constitution. Is that the board, the district, the faculty, the student? I don't know who that's referring to.
I believe that's referring to the individual who makes an allegation that there has been a Title IX complaint or issue.
And then can I have one more question of why is on page 7, the sentence at the top of the page italicized? Is that intentional?
I think it's just to draw attention again to the fact that the decision maker cannot be the same person that is also the investigator or the Title IX coordinator. I don't think that necessarily needs to be in italics, but that concept that the decision maker has to be a different person than the investigator or the coordinator is repeated throughout that final rule and this policy.
I'm going to guess that's just the way it was in the model policy that we used when we originally passed this.
That would be my guess also.
Great, thank you.
Any other questions? Ms. McDonough Souza?
Thank you. I just want to make clear, I think you did say this, Dr. Fedigan, but I'm assuming that the rescission and the new policy, that was all drafted with legal counsel, right?
It was.
I just want to make that clear. Okay,
Many
thank you.
conversations with Attorney Dugas, right, and this is under her advisement.
Thank you.
You're welcome.
Ms. Wolf-Boynton?
And just for my clarification, so up until now, 5145.5 and 44, both of them have already been part of the district. We're just rescinding one because the other covers everything that was in 5, plus uses all of the most current language.
Exactly. And having both, keep having 5145.5, I think, on the website has been confusing. In some circumstances, you can imagine whether administrators or parents, staff, stakeholders, they're confused. Which policy should they be looking at? And so, yeah, you're exactly right. They've both been there, but we really are saying that we should rescind 5145.5 for all the points we've discussed and that you outlined. You're welcome.
Any other questions? Mr. Fowler, Ms. Mulrenin, do you have any questions?
Yeah, just a quick question. Thank you, Ms. Glennon. I was just curious, how many Title IX coordinators can we have as a district, or do we currently have?
We currently have one Title IX coordinator. Our Title IX coordinator is our Director of Human Resources, Wendy Kapasna, and it's my understanding, and I've asked this question several times, actually, legal counsel, and it's been communicated to me that we can have one Title IX coordinator in the district.
Okay, great, thank you.
You're welcome.
Other questions on this? Okay, seeing none, then the rescission won't be voted on until the next meeting, so this is like a first reading of the rescission. Okay, thank you. We can move on to the next policy.
Okay, thank you, Mrs. Glennon and members of the board. The policy P3542.43 is a brand new policy, and it comes before us as the result of new legislation that deals with what has become known as shaming, and that is how you treat a student who has an unpaid balance in the food service in the food service accounts. And so with us tonight is our food service director, Mrs. Eileen Faustich. She can give you a very brief detail, but it's pretty self-explanatory. The district must, by state law, come up with a policy of how we handle unpaid balances and students who need to charge their meals, and that's what this policy does. So I'll turn it over to Mrs. Faustich.
Hello. All right, thank you. Good evening. Good evening. Can you hear me now? Okay. So this policy is, we've always had a lunch credit policy. It was not required to be a board policy, but due to the current new legislation, it is required to be a board policy this year for the first time. It documents what we have been doing. We want to make sure that we make sure every child can have lunch or breakfast whether they have money in their account or not. And we have always made sure we are not shaming a child, that we would always feed them. The newest restrictions are that it is a new Connecticut state law that we can't shame a child or give them a different meal or in any way single them out or embarrass them because they don't have money in their account. So that's what's outlined in this policy, and it also specifies how much debt we can allow the child to get into, how many meals we can give them before we refer the child or the account to our homeless liaison, Mr. Brown. So that's pretty much what this policy is all about. But it is specified. It is much more specific than it was in the past, and it really takes the concerns of the child and making sure they're okay and that they're not penalized or embarrassed in any way because they don't have money on their account. This policy is kind of irrelevant this year because we feed all the children breakfast and lunch, one of each of those meals every day without charge. It's all free of charge for all students, which is fantastic. We don't have nobody has to worry about whether they have money in their account. We feed everyone. But it is limited to one meal per meal session, one breakfast, one lunch. So if our free meals for all doesn't get extended past June 30th of this year, then we would go back to using the children's account and having parents would put money on their account, and they would have to, we would still obviously feed them, but we would account for that on the student's account and have to keep track and make sure that the money gets repaid. It is the family's responsibility to pay for their meals, and if there is some reason that it's not happening, then they would be referred for follow-up, but we do a lot of follow-up already. In the past, we would always contact the parents. We would give automatic negative balance letter messages at 4:30 in the afternoon, and it just continues until the money gets repaid. So does anyone have any questions?
Do we have any questions on this policy from Ms. Faustich or Mr. Michitelli? Ms. Ratner?
Thank you, Ms. Glennon. So, Ms. Faustich, my question is a simple one. It sounds like you're doing what you will be doing, because it's free right now, the same thing you already did before. So just having this now from the state requiring it is more of a formality legally.
Well, it is more of a formality, and it does restrict us. We can't give them a different meal, like if they reach a certain limit of how many meals they have received without bringing money. We can't get, sometimes we've given a cheese sandwich, and you can't do anything to embarrass a child or change what they're getting for a meal in any way.
Okay, so that was done before?
That is a bit of a difference, yes.
Okay, thank you.
Mm-hmm.
So that was one of my questions as well, because I know that this has come up in past discussions where a child that didn't have money on their account might have been given I think you called it a basic, a basic meal. So they can still choose whatever lunch they want, but my understanding is that there can be no a la carte or anything like that. It has to be just a full lunch they can get on credit.
Correct. It's only a meal. Anything, water or snacks or a cookie or something like that, that's all a la carte, and that we have never allowed students to charge that. It's only a meal. So no child goes hungry, and we take care of them.
All right, thank you. Other questions? Ms. Petrosky?
I guess mine is not so much of a question as an additional word that needs to be added on page 2 of 4. In the third
2
paragraph
of
up.
4?
Yep.
Okay.
In the third paragraph up that starts with money owed, the last line says, of a given academic school effective with the 2021-22 school year. I think we need to add year in the middle there. Of a given academic school year effective.
I actually had a question on this as well. So do we need to say effective with the 21-22 school year since we are in that school year? Does that have to be in there? I had made a suggestion, such debt must be paid by June 30th of a given academic school year.
Right.
Period. And then take out the effective 21-22 school year since we are in that year.
Yes, I believe the reason that was put in there is so that it defines when it was effective, what year it was effective, but we certainly could take that out.
Especially since for this school year, through the end of this school year, there is no charge. So there will never be a delinquent debt.
Right.
Yes, we can take that.
Okay.
We can make that modification.
Other questions? Ms. Wolf-Boynton?
So is this a significant problem?
It is not. It has not been a significant problem in the past. With all the reminders and the efforts that we take to get in touch with parents and give them an opportunity to put money on their account, it hasn't been in the past. The only concern that we have is that this Connecticut new law that went into effect, it doesn't allow us to limit the number of meals that a student can charge. Whereas we did in the past, we would, if it was excessive and we got no response, then we would give an alternate meal. But that's really down the road when we get no response. So there is no limit to how many meals they could charge, and that could increase our debt. But in the past, we have not had a problem with that.
So then if I'm understanding correctly, so this policy then the purpose is to show that we are in compliance with the new state guidelines?
Correct.
Okay, thanks.
Any other questions for Ms. Faustich? Mr. Fowler or Ms. Mulrenin, did you have any questions? Okay, thank you, Ms. Faustich.
Thank you.
Thank you. Mrs. Glennon and members of the board, the next policy before the board is policy 5144.2, entitled Use of Exclusionary Timeout Settings. What's important, I think, to note, one of the important things at the beginning of this policy in that introductory paragraph is the focus on proactive and preventative strategies that are a part of timeout settings. And also that final sentence in that first paragraph that talks about the fact that a timeout setting shall only be used in conjunction with a behavior management program which teaches and reinforces acceptable behaviors, except where it's necessary to remove a student from a potentially dangerous situation or an unanticipated situation. This policy, like others, has definitions that are important to note, including exclusionary timeout, seclusion, physical restraint, and the policy goes into different types of timeout. On page 2, it's important to note that the policy requires that the timeout setting space, if used, must be used as a behavioral intervention strategy, and that the whole purpose of that timeout setting is to teach and reinforce alternative appropriate behaviors that support student learning. Obviously, there's a focus throughout this policy on when a timeout setting is used, that the entire time a student is in a timeout setting, that they must be supervised in a supervised area or room, and again, that it's to help the student refocus self-control or to remove a student from a potentially dangerous situation. There are a number of rules and regulations that are outlined beginning on page 2 that would require our attention to use exclusionary timeout settings or spaces. For example, our staff obviously must be continuously monitoring students in a timeout setting, inclusive of the fact that the staff member must be able to see and hear students at all times, and at least one school employee must remain with the student or be immediately available to that student, and so that the staff member can communicate throughout the timeout. Some factors that might precipitate a student requiring a timeout setting: they fail to respond to less severe interventions, or if they're severely disruptive, or certainly if they're posing a danger to self or others. So obviously we have a number of strategies to promote student self-regulation and a number of preventative and proactive strategies which would be used obviously first. Our time limitations for the use of timeout settings. Page 3 indicates that a student's IEP shall specify when a behavioral intervention plan includes the use of a timeout setting with a student with a disability, including the maximum amount of time a student would need to be in timeout as a behavioral consequence. School administration and other personnel should be notified in the event that a student is placed in a timeout setting. So that happens, of course, in our course of practice in our work with students. If a student is placed in an exclusionary timeout setting, the administrator is noticed, as well as our school nurses, actually. In addition, notice that the Director of Pupil Personnel Services shall be responsible superintendent for establishing administrative practices and procedures, training our district staff. And of course, Brown is here tonight and can answer, along with me, any questions related to this policy. In addition, the school district, this is very important, has to notify and inform parents. So the school district shall inform students, parents, and guardians prior to the initiation of a behavioral intervention plan that would incorporate the use of timeout. And parents and guardians must be notified if their child were ever in a timeout setting for any amount of time in our school communities. And then with regard to the physical space used for timeout setting and space, that is outlined in an administrative regulation, and that is something that Mr. Brown will be working on with our district team. And the other thing to call your attention to is that there are two laws that are included under legal reference, two public acts, I should say, at the end of page 4. Public Act 12-88, an act concerning the reporting of children placed in, and Public Act 1851. That's the other act about implementing regulations of Department of Education. So those were added to this policy. And again, Mr. Brown and I are happy to answer any questions that you have.
We have questions for Ms. Fettigan or Mr. Brown on this. Ms. Ratner?
So, thank you, Ms. Glennon. So am I to understand, wait a second, let me see if I can come back to my questions here. Ms. Fettigan, that this really is IEP students, and they've worked with the behavior specialist, so the parents know about it and the student knows about it, that this could be part of the life for them as they're being educated if things don't go always as smoothly as need be for their management plan.
So If the student has a special education program, the behavior management plan needs to be included as part of the IEP. And if timeout is going to be a planned strategy or a planned intervention to support that student's behavior, that is part of the behavior intervention plan. That can be worked out with the special education teacher, the school psychologist, the social worker, or the school counselor to support the implementation of that plan.
Oh, thank you, Mr. Brown. So I guess I have a question for all of you then. Should it be saying at some point at the beginning, maybe on page 1, that it is just special ed that we're talking about here then? Students with an IEP for this, or that's understood?
Timeout is only for students who have an IEP. The policy states that if a student has an IEP,
Okay, I missed the if.
then it must be part of the IEP.
Okay.
Okay.
I obviously missed that. Thank you so much, Ms. Brown.
That's, thank you.
Ms. Wolf Boynton?
So I'm just building off of what Ms. Ratner said. So to me, it's very confusing about who this policy is for. And particularly, I mean, it's my understanding that a timeout is used immediately in response to an incident that is occurring. If a timeout's being used immediately or during the time an incident is occurring, how can the parents see the space beforehand?
We would, typically we're not surprised when a student is going to be supported by having timeout as part of the behavior plan. So we would do this in a thoughtful or deliberate way, and we would speak with the parent ahead of time. And in that case, we would be able to say to the parent, here is the timeout spot in the classroom that we will be using for timeout. Typically, the idea of a timeout space is a calming place. So it's usually where we would say to a student, you need to take some space. You need to have a break from what we're doing now. So go over to the calming space is what some classrooms call it. Some classrooms call it the Zen Den area of the classroom. Go over to the cubby, our cubby space. So it's not this punishment kind of a place as much as it is a time to take some space and settle down, whether they're feeling agitated for whatever the reason might be. It's not a scary place to go to timeout for a child.
No, I'm just trying, so I've had children who have been in timeout quite a few times when they were going through the Milford school system. And, you know, usually it consisted of a place within the classroom, or perhaps like right outside the door where they could still be seen. I'm just trying to understand, so so this policy is for children who have been several times, have gone through that in-classroom experience and it hasn't been affected, and now we're doing something more extreme? Because if I'm getting very lost about who this is for, and I worry about the statement about, you know, the parents will be informed, they'll get to see the space first. Doesn't that put us in danger of having to break the policy if we have an extreme situation at a classroom where a student has to be removed?
Thank you for the question. Let me see if I can clarify. So this policy is a required policy. So this is a policy that we are obligated to have, and the beginning sentence talks about the fact that students may sometimes include the use of exclusionary timeout settings, and it's typically, like you're talking about, Ms. Wolf-Boynton, a setting right there in the classroom. Typically there will be some tools right there to help the child de-escalate. Many times our students in typical classroom settings will actually choose to go to the timeout setting themselves, and I've actually heard children refer adults, not necessarily in school, but at home to their parents. I think, you know, now is time for a break or a timeout. So that is true, what you're talking about. There might be other settings that are exclusionary timeout settings, if you look under that first definition, that require monitored separation, that would be outside of, for example, like the typical grade 2 classroom. And I think the rest of what's in this policy, and that refers to the student's IEP, and that the student and the family, the parent or guardian, would see that space in advance, is referring to those spaces.
Okay, I just, again, I'm sorry to be repetitive. I just want to make sure that the section about the fact that the parent is allowed to see the space in advance and then I guess approve of the space in advance by saying that they get that advance notice isn't in some way prohibiting us to take a student out of the room when needed, when the parent, perhaps it's the first time the student has done something, but the situation is appropriate to take the student out of the room, even though it's the first time that it's happened. Do you understand what I'm saying?
I do, and I'm wondering if the language within the policy that talks about except where it's necessary to remove a student from a potentially dangerous situation or an unanticipated situation might cover that. I think, for the most part, when there would be a space outside of the classroom, it would be for a planned intervention like Mr. Brown is outlining and a part of the student's IEP. But I'm thinking that the other piece of the language here that talks about the potentially dangerous unanticipated might cover us for those, times that are not planned for and highly unusual and reactive.
Yeah, and even I think that up at the top of page 4, let's see here, is at the top of page 4, when the section where they're talking about they'll be notified, they can look at the section or the area in advance. That might not be possible 100% of the time. Right? If it could be a first-time incident where the student needs to be taken unanticipated, like you say. I just don't think it's clear there.
I'm wondering, to your point then, and it's something we can go back and look at with the language, I'm wondering if we borrow some of the language from elsewhere in the policy that talks about where it's necessary to remove the student because of the potentially dangerous situation or unanticipated. It might be helpful to replicate that language right there in that section.
Yeah, so right up at the top of page 4, it says, the school district shall inform the students, parents, guardians prior to the initiation of a behavioral intervention plan that will incorporate the use of a timeout setting for a student. Mm-hmm. So that's written in a way that assumes that only students will go into this exclusionary area if the parents have been informed and approved of that area in advance. And I just don't think that we can be sure that 100% of the time that will be the case.
That paragraph that you're referring to, that's when the timeout space is going to be used specifically as part of a behavior intervention plan. A behavior intervention plan is a very deliberate, planned out strategy that we would always include a parent in the development of that plan. So I think that's why it's listed in that way. This would be a plan that was developed either through the PPT process as part of a child's IEP or as part of an ongoing parent-staff team meeting. So it wouldn't be, a behavior intervention plan wouldn't be suddenly put into place or put into place in an emergency type situation, which is, I think that's the important piece of that paragraph.
Again, I just think it needs to be made very clear because it sounds like this is a policy for all students.
It is.
But you're saying it's not.
No.
I see what you're saying. I think we can take some time to go back and try to, while this policy is written for all students, there are some pieces that are referring to a special education process, like the one that Mr. Brown is pointing out, and I think what I hear you saying is it's unclear that there's a shift at that point in the policy that is really speaking to not every student, or, for example, is calling out the special education process, and we should probably be making that more clear.
Yeah, as Ms. Ratner asked as well, it starts off at the beginning of this policy, it sounds like it's for everyone. And then I totally understand now that it makes the shift, but that shift is not clear in the way that it's written.
So we'll go back and try to craft language to make that shift more clear in the policy, especially around that paragraph at the start of page 4. It might require us to reorder some things, I'm thinking, as I look at this, but we will take a look. Yes, absolutely.
If I could interject there, because I do have some concern now about what was just said, because the first paragraph very clearly states that a timeout setting shall only be used in conjunction with a behavior management program. So not every student has a behavior management program. So this policy applies to the use of exclusionary timeout settings, which is defined as a student being removed from a temporary, continuously monitored separation of a student from an ongoing activity in a non-locked setting for the purpose of calming. So that could be anywhere. I mean, that could be in the classroom, or it could be in a different room, depending on what the behavior management plan says. So this wouldn't apply to, a student who is just having a bad day and is getting out of line and maybe needs to go to the back of the classroom, and that is a practice that classroom management practice, I think, that is probably used fairly fluidly. So this policy does not apply to that situation.
No, it could apply to that.
It could.
So the difficulty here is that some of these terms in the policy, behavior management practices are general classroom management practices. A behavior intervention plan is a specific part of a child's IEP, and a behavior intervention plan is what's listed in that paragraph at the top of page 4.
All right. Okay. I did not see the differentiation.
It's our jargon
Yeah.
that's interfering with the understanding, which does happen.
Okay,
from time to time.
understood now.
Yeah.
Thank you.
So a behavior management plan is not relegated to only students who receive special education services. To the earlier point of the policy is more global, there's a more global application in the beginning, and then there's that shift for students who receive special education services and supports for behavior. Yeah.
Okay.
Yeah.
We'll give it- we'll give it-
capitalize behavior intervention plan.
While we're at it, we found a few more. We'll give it another go.
Okay. Ms. Doyle?
I think my point kind of fits with both the last two speakers, is I would like to see a little bit more clarifying language in who a behavior management program is part of the normal classroom activity management, and just clarifying, because I think that will make a big difference in that way. Thank you.
Petrosky?
So to your point that this could be anywhere, not just in a classroom, there is some jargon in here at the bottom of page 1 that it basically says under the inclusionary section, it's while full participation in a class. I'm assuming if they're in the lunchroom or in some other activity setting. So maybe some of the wording down here we might want to take a look at as well. Okay, thank you.
Ms. McDonough Souza?
Thank you. Can you just speak a little bit to what differences this written policy brings versus what we've been doing in the past, and if there's any necessary new training for staff members with this policy?
There aren't very many differences for what we're doing currently. As I mentioned earlier, classroom teachers will have places in their classroom for students to take a break or to have an opportunity to calm down, or just if they want to separate from the class for a minute or two. And that's been good teaching practice, good classroom management practice that's been in place for a generation. So that will continue. The purpose of this policy is to make it clear that we're going to keep doing it the right way, which is how we do it now, which is some of the language around the space and when it can be used, and that it shouldn't be a punishment. And it's just reiterating that the use of timeout should be to support a child, not to traumatize a child by having a timeout space.
Thank you. And one quick question. When we're talking about that they need to be continually monitored by a staff member, is that, we're not talking about another staff member, another individual in the classroom besides the classroom teacher, right?
Yeah, the intent there is to make sure that we don't ever have a child who we isolate somewhere alone, which could be frightening for a child to be put in a place where they don't know where the adult is or where their classmates are. So it's making it deliberately clear, if a child's in timeout, we still need to be supporting them. We need to be present with them, just as good practice.
Okay, thank you.
Do we have any other questions? Ms. Mulrenin or Mr. Fowler, do you have any questions? Ms. Mulrenin?
Hi, thank you. I just wanted to say that what Ms. Wolf-Boynton pointed out, I was also confused on that shift, so I appreciate you going back because I was reading it very confusingly as well in terms of if the language applied to someone who had an IEP versus the student who didn't. And I was wondering, even as Ms. Glennon just pointed out with the terminology of behavior management practices being different than behavior management plan, that maybe somehow those might be some definitions that you might want to consider to also help with the clarity on it, because the language, you guys know it because you're ingrained in it, but those who read it with not being ingrained in it, those kind of become blurred points that can be helpful for clarification. So I appreciate you going back and to look at it, and I just wanted to bring that in as another point of what I felt as well.
Thank you, Ms. Mulrenin. Mr. Fowler, are you good, or do you have any questions?
No questions.
Thank you.
Same concerns everyone else has had.
Okay.
All the concerns.
Anything else from board members on this? All right, thank you for taking a second look at that, Mr. Brown and Ms. Fettigan. Dr. Fettigan, sorry.
Okay, thank you. We will give it another go. The next policy before the board tonight is 6142.10, health education. And we're actually going to pull this policy tonight and not present just yet. And that's because we know that there is recent legislation around health education at the elementary level in particular. I've mentioned that before in previous instructional highlights. And also because there should be related administrative regulations that would support this policy with regard especially to recess and physical exercise in schools. And so we want to make sure that we get those administrative regulations a little bit further developed so we know what should go in those versus the policy. So we've made a decision. We just don't think this is quite yet ready to pull, and we anticipate bringing this before the board at some point in the near future.
Okay, thank you, Dr. Fettigan.
You're welcome.
So we go on to the National Honor Society policy.
Yes. Okay, so the next policy is policy 6145.51, National Honor Society, this is one of the best times of the year. It's happening in our high schools now. And this board policy really has not been approved since I guess the last proposal was in 1996, so it's time to look at it. We're not really recommending any significant changes. Just something that I would point out to this board is that this policy calls for the building principal to approve all of the activities and decisions of the local chapter. that also the principal appoints the National Honor Society advisor and the members of the faculty council. And the administration is directed to develop, again, appropriate regulations regarding Honor Society membership. And just as an aside, something that I think is wonderful for the board to think about is the National Honor Society, as you know, focuses on scholarship, leadership, service, and good character. And those are really the pillars of our vision of the learner that we're striving to support all students in developing during their time with us and all learners, including the adult learners in Milford Public Schools. So it's just something that has changed since 1996. Doesn't need to be called out in the policy, but it's kind of where you see policy enacted in our schools, in our learning communities. So I'm happy to take any questions about National Honor Society.
So, Dr. Fedigan, could you clarify for me? So the National Honor Society is a very specific organization, because we do have, I believe, some other honor societies that will be, isn't there a Tri-City or a Tri?
There is. This is a very specific honor society that we offer in our high schools. There are also various chapters that have to do with the arts. We have National Honor Society chapters that are kind of sub-chapters of National Honor Society for mathematics, and our different department staff, especially the department heads and those that are really the chairs or advisors of those run in each of our high schools. We have also National Honor Society for World Language. So there are chapters that fall beneath, but this is really to cover kind of the concept of National Honor Societies.
So those would all fall underneath this as well?
They would. Thank you
Okay.
for the question, for sure.
Do we have questions for board members? Ms. Doyle?
I know this seems like a weird question, but administration means superintendent and higher, or administration within individual schools?
Thank you for the question. So that would mean central office administration in partnership with our school principals and especially and instructional supervisors. We always want to make sure that we're doing that work in collaboration and partnership, because the regulation really related to the policy is all about how they implement within the schools. So that would be us engaging in that work together with them.
Any other questions on this policy? Mr. Fowler or Ms. Mulrenin? Okay, thank you.
Yes, okay, I'll take the last one. Okay, so policy P6145.8, we are recommending that be rescinded. That's the big X through it. I apologize for not on the agenda itself having it marked as rescind, but that was the intention. And the reason is in our normal rolling progression of review of these policies, when the 6,000s came up and we reviewed this one, we know that we already have a policy that we reviewed back in 2019, which is P3453, which is in your package, the last page of the package for reference. And 3453 does pretty much exactly what 6145.8 does. And since 3453 is more recent and goes into a little bit more detail, we feel that one sufficiently covers what we need to cover regarding student activity funds, and we recommend that 6145.8 be rescinded.
Thank you, Mr. Riccitelli. Do we have questions on this from board members? It seems to me having a 3,000 policy makes more sense, being a business non-instructional versus a 6,000. No questions from board members? Mr. Fowler, Ms. Mulrenin? Okay. I see none. So again, the rescission will come back as part of the second reading that we'll have with all of these policies at our business meeting, our March business meeting. And we'll rediscuss the 5144.2 with the changes that we've requested be made. Okay, so with that said, we're done with our policy work, and we'll move on to public comment. Just a notice that public comment tonight is, this is a committee of the whole meeting, so public comment is limited to agenda items only, which would be those policies that we just discussed. And I'll read the public comment statement. Speakers may offer objective comments about school operations and programs. The board encourages speakers not to express personal complaints or defamatory comments about the Milford Board of Education personnel or any person associated with Milford Public School System. Security issues and matters related to negotiations and grievances will not be permitted. Consistent with the principles of the Federal Education Right to Privacy Act, discussion of students is prohibited absent parental waiver. Public comment does not allow for two-way conversation between speakers and the board, but we welcome and appreciate your comments and opinions, and all will be taken into consideration. Public comment tonight is limited to agenda items only. Please note our meetings are televised and live streamed on YouTube, and we ask that you state your name and address for the record and limit your comments to 3 minutes. So if anybody in the audience, sir, if anyone is here for public comment, the microphone is up front here, up front there. And I see we have no public comment for this evening. So we will entertain a motion to adjourn.
Motion to adjourn.
We have a motion to adjourn from Ms. Petrosky. Is there a second? Second for adjournment? Mr. Fowler seconds. Is there anybody opposed to adjournment at 7:59? Seeing none, we'll stand adjourned. We'll see you all on the 14th of March. Thank you all.